Real quickly before we begin, I want to thank this video's sponsor, CarMarshal.com. CarMarshal.com can save you lots of money on buying used or new vehicles, cars, trucks, school buses. If you want to save money, I'll have a link in the description down below.
I'd like to welcome everyone to the We the People meeting and assembly call for March 9th, 2018.
Very nice.
The call is an open call. We do try to stay on subject of how to reestablish our government centered under our constitutions. We do invite our public servants to the call to learn from the history and the archaeology we've done to learn about the system that the founders set up for us. We have some very simple rules. If you want to speak, wait until the previous speaker finishes and then say, "May I?" thereby requesting the floor. Once you're granted the floor, try to get to your point as succinctly as possible. And when you finish, say, "I yield." That way, people are not speaking on top of each other, and we can have a reasonable conversation and transfer of information.
This is Robert.
Great. Thanks, Robert. So I'd like to start out with a little news. Then I'm going to take you over to a website that is WeThePeopleCommonLawGrandJury.com. So for those of you that have access to the web while you're on the call, you can be loading that page up, WeThePeopleCommonLawGrandJury.com, because I want to show you some of the process that's going on by the grand jury in the Charlotte County case of my brother, Dave Dowdell. So to begin with the news, today I had a conversation with Anna von Reitz and learned from her that on May 5th, Trump was in Paris and he signed an agreement to establish a new French-based corporation entity called, all capital letters, Republic of the United States. And unfortunately to me, that's pretty bad news because this is an attempt by the cabal to replay the fraud. And it implies to me that either President Trump doesn't understand the fraud or is complicit in trying to start a new version of the fraud. So Jim Belcher, who is the head of state historically, did send a notice that corporation has no contract with the people of the United States of America, and therefore they can do whatever they want to do in France, but they have no contract here. In addition, Anna mentioned that the IMF has made its move in the last few days by opening up new offices in North Carolina and claiming to be priority creditors to the bankruptcy of the territorial United States of America. As a result of this, Anna needs to raise about $25,000 to send a team to the Vatican to petition for the liquidation of the IMF. And then she needs to send a couple more people to the World Court in The Hague to make sure that the world understands that we, the people, are the priority creditors for the bankruptcy. So if you can contribute to Anna's effort, please do. And if you know of anybody that might be interested in contributing, please do. Of the $25,000 or $30,000 she needs to raise, since her call for funds went out a 3 days ago, she said that they have raised $3,500 towards the goal. In addition, on the news, the QAnon has stated that as of yesterday, QAnon stated, "Today, evil lost control and leverage in Iran. Today, POTUS took control of Iran." Now, I frankly don't comprehend exactly what is going on. but somehow this is related to the plane loads of cash that Obama sent to Iran just before leaving office. It turns out that this Iran deal, if you will, or contract, was never a treaty. It was never submitted to the Senate to be voted on. So therefore, it is like a private contract between two corporate entities. From different sources, I've learned that the terms of the contract required $250 billion of American money to be given to Iran every year. What was the purpose of the cash and how was it to be used? Who knows? I don't have a clue. My guess is a bunch of it went on to the cabal, and this was basically...
Did you say it the other night? It's John Deere Green now.
Hey, could you mute yourself, please, Roland?
Yes.
Thank you. So somewhere around $250 billion a year was being extorted from the United States as part of this deal. It's pretty strange to have the Premier of France and the Chancellor of Germany fly to the White House and try to convince Trump not to back out of the deal. But he did, in a White House ceremony, he backed out. We are no longer party to that deal. And what exactly that means isn't clear, but it is clear to me that it is significant, whatever the results are. And it appears to me on the surface that both North Korea and Iran were being used by the CIA to extort money on behalf of the cabal in an attempt that they had to control those two states in order to try to create World War III. And I know it sounds bizarre, but that's what it appears to be from the evidence that I'm aware of. One other thing that I learned from my discussion with Anna that is pretty important, and yet we don't fully comprehend how to utilize it, because both the municipal United States, all caps, and the territorial United States, upper and lowercase, went into bankruptcy, they were the two entities that caused the fraudulent overlay over the de jure states like Florida. And the net result of that bankruptcy, entering bankruptcy, is they became incompetent, and therefore the delegated powers automatically reverted to the United States of America, upper and lower case, as defined in the Articles of Confederation. That is the political union of the states, not the Government Services Corporation. So that's pretty significant, because all of the fraud about our identity and our straw man and all of that was implemented through these two corporate entities, the territorial states and the municipal government. So right now may be a window that we need to figure out how to exploit to our best benefit. The average people in the states think that they are free, sovereign, independent Americans, but they volunteered to be U.S. citizens, and that means subject of these corporations. And it may be possible for them to simply identify the state upon which they were born and thereby claim their birthright, free, sovereign American status.
Wow.
Two more quick items. One is one of our Patriot members in Florida forwarded me last week a Alex Jones session where he had a guest speaker who talked about the electromagnetic radiation coming from the new 5G cell towers. So the cellular providers think that it's more and more important to give people higher and higher frequency, and that frequency allows more broadband information, more video information to be transferred to your cell phone. However, the frequencies involved in 5G are of the wavelength that resonates with a water molecule. And therefore, what it's been shown to do in a lab environment is it breaks down the blood-brain barrier in humans. Now, they've done it in mice, but I don't think they've done it in humans. So the danger is that this new technology called 5G could represent a very, very serious threat to human health, and we the people may have to dig in and get the information and hold our public servants accountable for preventing this radiation from being broadly spread out and damaging human health. And then the last piece of news this evening is I want everyone to be alerted to the fact that we are entering a 40-year period called the Grand Solar Minimum. Who can tell me what is the Grand Solar Minimum?
May I?
Yes, please.
I'm pretty sure it's the sun getting cooler and cooler and cooler.
Well, I'm not sure exactly what happens to the temperature of the sun, but it is a periodic reduction in the number of sunspots. And sunspots are responsible to a large extent for the weather patterns on our planet. This reduction in the number of sunspots happens approximately every 400 years. So far, the evidence that is starting to mount is that this past month of April was the coldest month in 20 years. So in the face of everybody claiming so-called global warming, we're actually doing just the opposite. We're going into a global cooling period. In fact, for the state of Wisconsin, the month of April that just passed broke all historical records for cold in the state of Wisconsin. The last time this kind of event occurred, about 400 years ago, the history books will talk about the year with no summer. So what happens is that the northern climates in the United States north of the 45th parallel that are growing food, they end up losing their growing season because of freak storms and just cold in general. So 400 years ago, people starved in this country and in Europe. So look it up and do your own research, but I would advise everybody to alert themselves, their families, and their friends to hopefully put away some extra food just in case we do have a year without summer. This is expected to reach the coldest point, this 40-year period, the coldest point is expected sometime between the year 2030 and the year 2032. If you want to, you can look up on YouTube, I think his name is John Kasey, C-A-S-E-Y, who is a scientist who has done multiple YouTube videos on this period of cooling, the Grand Solar Minimum, and he has written a couple of different books about it. Okay, any questions on the news?
May I?
If I may.
Lady first.
I need the address that you told us. We the People.
CommonLawGrandJury.com.
CommonLawGrandJury.com. Thank you.
You're welcome. Yes, Don.
That was Chris.
Oh, Chris. Sorry.
Yeah, Roger. I'm really skeptical of Anna von Reitz. Every time, she goes off on some grandiose, we go down some path we can never get to the end of, and I don't see any results from her. And it's always and now she's asking for money. And I remember when John Darash did this, nothing happened with the money that he got. So I'm skeptical when these type of things happen. And it's always something that's outlandish. Never something that you can even kind of wrap your arms around and say, you know what, that might be true. It's always something there's no way to check it out, except to listen to her. And I stopped getting her emails because she's so far out there. So I'm done. Thank you.
Okay.
I yield.
To add to what you said, she has been involved in doing some papers that are very difficult for me to wrap my mind around and comprehend, and her essays also. But at the end of the day, I think it's a different situation than with John Darash, who we know, and he admitted to me, John Darash runs the National Liberty Alliance, and he admitted to me that wasn't even his own name. His real name is John Vidurik. So
that's right. He's not an honorable person. Right.
So that's a very different situation, in my opinion. But I understand what you're saying. It is complex. Anna has had 2 different conferences where a group of people went to Alaska. I was invited. I couldn't go for a personal conflict, but Bruce Doucette did go. And he did meet a group of very good patriots who are helping people on a daily basis get out of the system and helping them from the attacks they're under from the de facto. I've talked to 3 or 4 of them on the line. I don't think of them as friends, but just basic acquaintances. Mm-hmm. So I think there's more substance to what's going on there. But I agree, it is not at the grassroots level. It is at the international level between the entities like the IMF, the UN, the Vatican, etc., and City of London. So,
again,
and the Queen.
That gives you the heebie-jeebies right there. And then we know where Bruce Doucette is, right?
Right.
Okay.
Right.
So, all right.
Okay, so
thank you.
And any other questions or comments about the news? If not, I would like to change over now and go to the We the People, CommonLawGrandJury.com. I need people to scroll down to near the bottom to what is called Felony Crime Count Number 62, Dowdell Common Law Public Trial. Let me repeat that. Felony Crime Count Number 62, Dowdell Common Law Public Trial.
Is there a date there?
12/27/2017. I need someone to tell me if they've been able to pull that up. It's not quite at the bottom. It's 1 or 2 up from the bottom.
I have it up.
Okay, good. So now, what are we looking at? This is a website where the grand jury in Florida, the grand jury in Nebraska, the grand jury in Oregon and Idaho and Nevada are depositing evidence of criminality. And eventually, when we get to the appropriate point in time, the evidence will be gathered together and will represent a presentment to the accused, giving them 40 days to rebut the facts that are being put forward in this evidence. So there are 2 parts to each one of these. On the left-hand side, you will see 4 video, click here, and then right below it, in yellow, again, it says 4 documents, click page link. Does anybody see the one that says 4 documents, click page link?
Yep.
Okay, I need you to click that page link. We're going to go look at the documents.
What's the date on this?
12/27/2017.
12/27.
Felony crime count number 62.
Okay, it's loading. I got it.
So is that Bundy common law public trial?
No, it's just above Bundy. Felony count number 62. It says Dowdell instead of Bundy. It says Dowdell common law public trial.
All right, so I just click on that.
Well, yes,
for documents,
you have
page.
in the left-hand column it says click for the video, click here, and then it says for the documents, click here, and you want to click on the document link.
Got it.
Okay, now for everybody's benefit, when this comes up, you can see some pictures of people, and you notice that one of them, Caitlin E. Sorensen, we're missing her picture. So we need some good help from the folks in Charlotte County to get Caitlin E. Sorensen's picture. On the far right is David Allen Dowdell. That's my younger brother. I have 3 younger brothers. That's the middle one. And he is got a handyman business in Charlotte County doing painting, carpentry, and cement work. Now, the first document I want to call your attention to is called an affidavit. Who can tell me what is an affidavit?
Sworn statement.
It's a sworn statement, but how do you go about writing an affidavit? What is in bounds for an affidavit? What is out of bounds?
I guess just
personal affidavit.
I'm sorry?
It's a personal affidavit of truth.
Right. So what's out of bounds is you cannot put any opinion, any speculation, any emotional claims into it. It is strictly a factual statement of what happened. So look at this affidavit. It begins by saying, I, David Allen Dowdell, with domicile at such and such, as one people of we the people. And then it goes to number 1. On December 27, 2017, while eating lunch, David Allen Dowdell received a phone call from someone identifying himself as the driver for United Parcels Service. This phone call and subsequent calls referenced in this affidavit came from the number 941-769-2598. Okay, so notice in this first paragraph, the first number, we didn't say what he was eating for lunch. We didn't say anything that wasn't relevant to the case. We didn't talk about the weather or where he was. If where he was important to the case, we would have put it in. So what was important was the date, and he received a call, and the call came from a certain number. The next statement, the person who called David Allen Dowdell stated that UPS had a package for David Allen Dowdell and that it was put on the wrong truck. Number 3, the supervisor is going to bring it to the UPS distribution center located on Kings Highway, Port Charlotte. Okay, so then the caller instructed David Allen Dowdell to come to the location. Now, I happen to know from the conversation with my brother that, well, here it is. They continued to call him, and then number 7, finally, later in the day while at work, requested that they just deliver to David Allen Dowdell the next day. So he even said, no, I can't come down. You deliver it the next day. And they claimed that this was not possible because some scanning issue, and that David Allen Dowdell had to come to the location to pick it up. Okay, well, that could have been the first tip-off that something was going on, right? So when is it that the UPS guys ever refused to deliver a package? In fact, if you look at their policy, their policy is that they will try to deliver any package 3 times, and only upon the 3rd time do they force you to come pick it up. Okay, but I'm not going to dwell on any of this particular case. I just want everybody to understand this is how an affidavit is written. And then further on down on the page, it states on the couple pages down, he signs it and it says, further the affiant saith not, and he swears to it in front of a notary public. Okay? So that's very important. And he states above, I have carefully read the foregoing affidavit, and each of the facts alleged therein are true and correct of my own personal knowledge. Okay? Now, in our system of law, an affidavit put onto the public record, unrebutted for 30 days, becomes the truth. Now let that sink in. That is so important. That is a foundational element of how our whole judicial system works. How are you ever going to find the truth? Well, you could decide what you're going to do is you're going to set up a bunch of investigators, and they're going to go interview everybody, and then they're going to try to sort out who's lying and who's not. Or you could say, well, what you got to do is you got to do an affidavit under oath, get it notarized, and then if you're lying and we find out you're lying, you get penalized. And all of your testimony gets removed because you're no longer believable. So that's how this whole system works. Notice that it's got the seal of the statewide grand jury at the bottom. And it got entered into the public record. Then a copy of this document got filed, a certified copy got pulled out of the public record and filed into the court case. Now, why is it important to put it into the public record and take a certified copy out? Why can't we just put a copy of this into the court case? Well, because the courts are not courts of justice. They are administrative courts, and the judges are not real judges. They are administrators. So therefore, what we've experienced across the country is different cases. Evidence is lost, evidence is misplaced, evidence is ignored. But when you put it into the public record and then take a certified copy and put it into the court case, then the evidence has to be observed. And that's what we found going on across the country. Any questions about an affidavit? Comments?
May I?
Yes.
Let me just get in my head. Is you got to go. This is the first time I heard this. You go ahead and do the affidavit, and you put it in the court clerk, and then you give them 30 days to dispute it.
No. Let me repeat it, and then follow up if I don't make this clear. So you draft the affidavit. You sign it in front of a notary. And you get it submitted to the administrative investigator for the grand jury, and they put the grand jury seal on it. Okay, so that sends the signal that this case is not in the statutory domain, this is in the common law domain, because it's got the common law grand jury.
The statewide.
Then you take that affidavit to the clerk of the court in Florida. It may be other offices in other states, but in Florida, it's the clerk of the court. The clerk of the court maintains 2 separate files. One file is the public record, and the other file is the records for the court cases. You file it into the public record and take a certified copy out of the public record and file that into the court case.
Got it. So just to repeat this, is you do the affidavit, then the statewide grand jury or the local grand jury in that vicinity, right?
Yes.
Okay. And then they get it certified, seal it, and then they hold it for 30 days?
No, then you take it, either the administrator or the victim takes it and files it into the public record.
Public record, yeah.
Takes a certified copy out, files it into the court case.
Mm-hmm.
Now, the clock for the 30 days starts once it's in the public record.
Got it.
And if it stands unrebutted for 30 days, it is the truth. It is considered the truth in our judicial system.
Okay, I got it.
Okay, I need you to scroll down to the next document. The next document is titled Demand to Amend with No Delay. Does anyone see that next document?
Got it. Exhibit 2.
Okay, those words come from the Magna Carta. And it's a very simple document, right? 2 short paragraphs. I, David Allen Dowdell, one people of we the people, in sui juris, in discord with civil servants, I am victim for multiple constitutional crimes de son tort, which means of their own wrong, committed by de facto elected or appointed officers of the United States of America. Wherefore, in accordance with the forever supreme law of the land, I demand to amend with no delay in 40 days for remedy to my deprived constitutional unalienable rights. So what is this document's purpose? This document's purpose is, again, to document that David Allen Dowdell is being attacked and has asked for help by the grand jury in writing. It is another notice to the de facto that this case is a case in common law. They can do whatever they want to do in statutory law, but this one is in the common law jurisdiction. Again, it gets sealed by the administrative investigator as another exhibit of the case in the common law. Now, let me summarize something. Now, we've looked at the affidavit and we've looked at the demand to amend with no delay. Notice what is going on. These documents are being filed into the public on this website, WeThePeopleCommonLawGrandJury.com. So what is going on? This is actually a trial that is taking place in the paper. This is how almost all trials were done years ago. And then the bar, in their effort to brainwash us, did a partnership with Hollywood and developed a show that was popular when I was a kid called Perry Mason.
Oh, remember.
And in Perry Mason, we all got brainwashed about what a trial was. And that gave the bar the upper hand and the judge the upper hand to control things. But when you do a trial, remember, the constitutional requirement is a speedy and public trial. Well, if you're going to do a speedy and public trial, and you commit to doing it in writing, because verbally records can be changed, audio things can be overwritten, audio recordings, etc. So when you do it in writing, and you do it so that the public can see it. So not only are these documents filed into the public record, but they're also put on this web server so anybody can see them. Any questions about a public and speedy trial in the paperwork? Okay, the next document is a document from the sheriff that talks about the arrest and the charges on the second page And now it becomes an important comment to make here. When you have people depriving one of the people of their rights, you could elect to treat them all as one entity, or you can treat them as separate entities if in fact they're set up as separate entities and they are supposed to be operating as separate entities. So in this particular case, the administrators have chosen to treat the judge and the prosecutor as the 20th Judicial Circuit as separate entities, and therefore they, when the record is completed, if they cannot rebut the evidence, then the evidence will show that although they're separate entities, they're working together to deprive people rights, and that is a conspiracy. In the statutory domain, that is known as RICO. And what's the penalty for RICO? Under U.S. Code, under RICO, you lose everything, except maybe your homestead. Okay, so now let's keep going down, and you see a document called at the top that says Statewide Common Law Grand Jury, Florida. This is dated February 7th, 2017, and it's a demand to provide oath of office and surety bond. Now, what happened in this case is that the grand jury administrators went to the sheriff's office, to the clerk in charge of the records, and educated her a bit on the law, and especially the law that comes, the common law comes from the Magna Carta, and demanded to see the oaths and the bonds for everybody involved in this criminal kidnapping of my brother. The clerk said, okay, we will email them to you. However, the emails never showed up. So the first hearing is due on, I think it was Monday, February 9th or 10th. I have to check the date. So on the 7th, the grand jury administrators had professional process servers serve the assistant state attorney and everybody involved in the case with the demand to provide oath of office and surety bond. While the process server was at the assistant state attorney's office, I think that's the office he was at, he was told that the case had been closed. And he called the administrator and asked what to do, and the administrator said, you keep serving these documents because they can do whatever they want with a statutory case. They can close it or whatever they want to do, but that does not influence the common law case. We have an injured party. The injured party has asked for help with the grand jury, and it's the grand jury's duty now to carry the case forward for justice, which is, by definition, the restoration of the injured party. The injured party must be restored. Notice that it says for immediate press release. Who can tell me why those words are there?
So it gets out into the public through public notice.
Exactly. It's all about the fact that if we as the people create documents and they are not labeled press release, then they are not covered by the First Amendment in this statutory tyrannical system. So we learned 4 years ago that we needed to make sure we put press release on the documents. Okay, so there's a sequence of those with a certificate of service and then a receipt from the process server company called Legal Process Service. Any questions on this? So you're seeing how the case is progressing. Now there's an order, notice the order for the oaths and the bonds, right, is dated, when was it dated? February 7th. And they had 14 days from February 7th, so that'd be February 21st, in which to provide the oaths of office and surety bonds.
If I may?
Yes.
On the when you requested by email the bonds of each and every one of them, was that under the statute of a records request?
No, we never did that. No one did that by email. If I said that, I misspoke. The way it occurred was the grand jury administrators went to the sheriff's office in Charlotte County and went with a very courteous effort to meet with the clerk of the records of the sheriff's office. They explained to the clerk the common law requirements and then demanded the oaths and the bonds, and the clerk said, okay, I will email them to you.
Well, by law, they can't even ask that. I mean, you should be able to stay there and wait for it. You don't have to give them your name. You don't have to give them an email. You don't have to give them a phone number.
Well, I'm sure you're right, but the issue here is that this is not one of the people. This is the grand jury, and we want the de facto officials to understand that they are working with a statewide grand jury investigator. This is important because they are not used to this. We need to educate them that the grand jury is the entity that the founders set up that has the authority to reach into both the jurisdiction of the common law and of the statutes. It is the one element that can reach into both. Okay? Any other questions? Okay, so now we continue down, and let's see if there's anything on the file beyond this. More of the process servers and the notice, more exhibits. Then there's an orange document that is the sheriff's record of the inventory of the vehicle. And then there's a document dated February 9th from the Office of the State Attorney, 20th Judicial Circuit of Florida, notice to the clerk. And this is where the state attorney notices the clerk that they are not filing the charge. 893.13, 823.10, and 893.147. Okay, so any questions about a public and speedy trial? You can keep going through here. You will see more evidence, and we need some help to get some more pictures of the people involved. Now, 5 states are working together to get their grand juries up and running, to get the evidence accumulated in this website, to get it on the public record, so that we have the evidence of the lawlessness with harmful intent that is being deployed by the de facto agents, whether they're elected or appointed, against the people. Any questions or comments on this?
May I?
Yes.
What's the status of your brother right now?
He's busy working in his business.
Ah, good.
Okay, notice now, just to summarize, everything has to go into the public record, and a copy we put on WeThePeopleCommonLawGrandJury.com, and it is a public and speedy trial in the paperwork, and an affidavit unrebutted for 30 days on the public record becomes truth in the system. That's a very, very powerful thing to know, because in today's environment, there's such arrogance, complacency, and tyranny coming from the de facto against the people that they pretty much think they can get away with anything. And when you begin to hold them accountable to their oaths and their bonds, is when you begin to correct the defective behavior. And it's a lawful process. It's all lawful. We need to educate more and more people about this, and we need to get people set up so that they understand how to help people write affidavits that will be successful. And then the last thing I'd like to mention, if you continue to scroll through, you will see multiple slides put together that talk about issues like the supremacy law, the Bill of Rights, the Bill of Prohibitions, and it is done to educate the de facto. Even the attorneys, the county attorneys, the state attorneys, they've never learned common law. They've never learned much about the Constitution, if anything at all. It's all been pulled out of the law schools. So it's our duty to do the best job we can to lay out the law of the case that's appropriate. As an example, the right of the people to be secure in their persons, houses, papers, and effects, the Fourth Amendment, against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, that's the Fourth Amendment. And to my knowledge, none of the de facto law enforcement folks are following the supreme law of the land. That's a very serious crime called contempt of Constitution. It's one step below treason. So we've got to educate them. Some of them are doing what they're told. Some of them are doing what they know is wrong, but doing it for a paycheck. And some of them are just pure evil and doing it for the purposes of hurting people. So we've got to educate them and sort it out. And then those that continue, after being educated, continue to do evil works against the people will need to be held accountable to the rule of law.
Roger, if I may.
Yes.
There's a lot of videos they can click on and get. It explains a lot that's going on. And then further down, where you see those, where the screen turns black and it shows you the Constitution, you know, with George Washington on the right there, and it says in red, the Constitution for the United States of America. It's important that if people look down below, like you just mentioned, the Supremacy Clause, Clause 2 and 3, and then further down, you know, Amendment 4, like you mentioned, those are important that they go and take a look at those so they know what they are. You know, Amendment 7, you know, no court, you know, shall re-examine any fact tried by a jury. So it's important that you take a look at everything there. It's just sometimes it kind of disappears in the landscape here, but if you look at the things that are in yellow, It explains even some of the Florida statutes, like Title I, Chapter 2 of the Common Law. It's amazing if you look at some of that stuff there too. So I yield.
The big issues are defined. The administrative investigators have done a great job here posting up things like the definition of racketeering in Black's Law, things like the Magna Carta and the parts of the Magna Carta that are appropriate. Remember, on exhibit number 31, for example, it says, "This charter is justly regarded as the foundation of the English constitutional liberty. Among its 38 chapters are found provisions for regulating the administration of justice." That is very, very important. Securing the personal liberty of the subject and his rights of property and the limits of taxation. Now, we're not subjects, but this was written for the British citizens that were subjects to the king. When we got founded as a country, long before the Revolutionary War, there was common law on the land in this country. And it morphed quite a bit into what's called American common law. And that is what the founders and their brethren practiced, that as soon as they snipped the cord to the king, they became the highest ranking sovereign in the system. Any questions or comments?
May I?
Yes.
In this particular case that's being referenced, is the case at an end, or is there a remedy still being sought?
No, it's in process. And the next step, so more evidence needs to be gathered. In particular, the evidence that has been gathered points towards a conspiracy between the corporation that is running the Sheriff's Department in Charlotte County and the corporation called UPS, United Parcel Service. We need to gain some more evidence whether or not there are other victims in Charlotte County. And Andrew Sheets did a FOIA request, and they answered that there were 87 emails in their files that were relevant to the FOIA request of other, what Andrew called busts that were held at UPS Distribution Center. So we still don't have those in our hands yet. We have to wordsmith our document. Apparently we did something wrong with the words we used. But at any rate, that is leading us to think that there are more victims in Charlotte County, and we now need to go to other counties to examine the record there to see if the same thing is going on there. And that work still is to be done. Then a ribbon will be wrapped around the whole thing with a presentment. And the presentment will be served by process servers or the administrative investigators on the accused, and that starts the 40-day clock. And after the 40-day clock is over, you typically get one of three results. One result is the accused said, "Oh, I'm very sorry, I didn't know I was creating an injured party. I will stop the behavior right away and I will restore the victim." Today, that's very unusual with any de facto organization. We haven't seen that happen. The second possible result is that one or more of the accused would put forward evidence to rebut the presentment. For example, say there was a John Smith that was involved as an accused and was served a presentment. He may come forward with evidence of an airplane ticket and a hotel receipt proving that he was out of the state at the time and that the grand jury presented the wrong John Smith. So then the grand jury would need to adjust the paperwork and do some more research, okay? But then the third result is the most likely result. After 40 days, if the grand jury administrators have done their job, the evidence is fact-based and cannot be rebutted. So the accused will acquiesce and do nothing. Upon the 40th day expiring, by doing nothing, they convert themselves from accused to being criminals. They convict themselves. Now, the only case where there needs to be a trial by the jury of 12 in common law is if the accused rebuts the presentment, but the rebuttal does not convince the grand jury that the accused is innocent. Then it must go to a jury trial of the 12. Now, the last two steps after the acquiescence is a claim of distrain and a claim of distress. A claim of distrain you can think of as being similar to a lien intended to freeze the assets of the criminals. They're now criminals. Their assets get frozen in order to make sure there's assets available to restore the victim. And then the claim of distrain is when the whole community rises up and takes whatever assets are necessary that have been distrained, whatever assets are necessary to restore the victim. So those last two steps would come after the 40-day period, after if the accused acquiesced to the presentment. Any questions on the process?
May I?
Yes.
This is Paul. This is Paul from West Palm Beach. A couple of things. When you say the accused will be, or they will be restored, is this as a fine against like the sheriff, this prosecutor, and so forth, and then they would sell their homes and so forth, where they would be? Is that what we're talking about?
I'm sorry. Who are you, please?
Yeah, this is Paul. Paul from West Palm Beach.
Paul from West Palm Beach. Okay, Paul. This is a particular case that we've been discussing in particular to train people how to do affidavits, et cetera, and how the whole process works, the grand jury process.
Yes.
So in this particular case, there are specifics about this case. The victim, who happens to be my brother, David Dowdell, was entrapped by a combination of the UPS Corporation and the corporation running the sheriff's office in Charlotte County, working together to entrap my brother.
Yeah, I see that. I've got this online. I see it here, Roger.
Right, but this case, this process would be used in any case. It can be used if there's a foreclosure case, if there's any kind of problem, any injury, any injured party.
Yeah. How about the U.S. District Court in the state of Florida? Can this process be used there in that situation?
I'm unclear. If the court was to do something that creates an injured party and the injured party wants help from the grand jury, then yes, it can. The grand jury can act. Yeah.
Okay. This is the first. This is brand new to me. I'm familiar with a lot of things, but I've never seen this before.
Right.
This is wonderful. And this is the statewide common law grand jury, Florida. This is the address here. I see. Is it
what we use
Florida?
Each time we set it up, we use the address of the victim, so that all correspondence goes through the victim, and the victim can stay in touch and help the grand jury administrator stay up with the case.
Yes. Okay. Very good. Well, yeah, thank you. This is great information.
Great.
And by the way, that information from Anna Van Wright's, that's heavy-duty stuff that's going on right now.
Great.
We've got to. It seems to be pretty serious what these corporations are trying to do to all its, non-citizens, nationals, if you will.
Right.
So, this is great. So thank you very much for the input. I appreciate it. Thank you.
You're welcome. Okay, someone else thinks Santa Claus asked for the floor?
Yeah. And
Can you speak up a little bit, please?
Can you hear me?
Yes.
Okay. And the theory is that the criminals, which are at least all of the bar mafia, will peacefully surrender and go start living under bridges. Because
that would be ideal, but that's not necessary. If necessary, the common law has Article 48 in the Magna Carta. Article 48 in the Magna Carta says that the honest people in the county select 12 knights, and those knights are secret. They are not exposed to the public. And those 12 knights have a mission to eliminate the evil customs in such a manner that they can never come back.
Well, they came back.
Okay. Yeah.
Well, nobody used Article 48, I guess, then.
Yeah. I don't know.
If I may?
Yes.
Okay, I yield.
Thank you. Yeah, there's still going to be admiralty courts and all that for them to play in. So that
I can't hear you, Chris. Could you speak up?
There's still going to be admiralty courts and all those type of courts for them to play in.
Yes.
So they're not going away.
Right. But what will likely happen is as we gain progress and as some of the early stories of the de facto officials causing injured parties get known, and the fact that they're being held accountable for the first time in maybe 50 or 100 years. Well, if you go back, I think it was 1956 was the last evidence of a grand jury, a people's grand jury operating.
Correct.
So if you go back before 1956, the records would show that this was happening all the time. Mm-hmm. But I forget it was 1946, the bar tried to subdue the grand jury and put it out of business by claiming that a presentment was obsolete. And it isn't obsolete. It's in the 7th Amendment. It cannot be, the presentment is mentioned in the 5th Amendment. It cannot be declared obsolete by the bar.
I think the other thing that I'm concerned about, too, is I understand there's some people that are going around Florida, knocking on doors to see if people have had the same type of thing happening, and they're going to UPS and all that kind of stuff. And if they're not following this procedure, that's going to hurt us, I think.
I'm unfamiliar with what you're talking about.
Well, I just heard some people are going around, finding out there's more than one person that this has happened to. And
wait a minute. What's this? Are you talking about the entrapment?
Yeah.
And people are going around doing what?
Trying to find other people that this has happened to.
Other victims.
Yes.
Okay, and you're concerned because of what?
Are they following what we have on We the People common law grand jury? Are they writing them all up, or are they just kind of going out on their own? That could be a problem.
Okay, I have no idea of who you're talking about going around, so maybe we have a separate conversation about that offline.
Okay. Well, I saw one email come across my email server, and it was on, some guy was using some foul language about it. So that's not going to help us.
Oh, okay. Yep.
Okay. I yield. Thank you.
You're welcome.
May I?
Yes.
Is there a time limit on the next phase of this?
No.
No? Okay. I yield.
And please remember that much of what is being done to people and things like fraudulent foreclosures and things is fraud. It's identity theft, all kinds of stuff. And there is no statute of limitations in common law. An injured party is an injured party, And whenever they come forward and want help by the grand jury, it's the grand jury's duty, along with the administrative investigators, to help the victim. One of the key elements is that, I forgot the exact quote. Chris, maybe you could help me out here on the quote about justice not for sale. Chris, are you there?
Yes, that would be clause number 40 in the Magna Carta.
Any chance you could read it or recite it briefly?
Yes, give me a second.
Okay.
I can't recite it off the top of my head, but I've got it here. So it's only one sentence, too. To none shall we, oh, brother, hang on for a second. To none will we sell, to none will we deny, delay, right, or justice. To none will we sell, to none will we deny or delay, right, or justice. That's clause 40. And that's where the money thing comes in.
Thank you.
So you can't get money for doing the job.
Now there will be likely cases where if the injured party needs to get restored, and if the evidence points to the intent. What do we mean by that? We mean that normally you would restore the victim, but under common law, if the damage was done to the victim intentionally, in other words, knowingly by people who are supposed to be deemed to know the law, like clerks, judges, sheriffs, then triple damages come into play. So you take the damages required to restore the victim, and then you triple that number, and you add it to the damages to restore the victim. And the victim is asked to donate those funds to help the grand jury help others, so that the victim gets restored and the grand jury gets funded so that we can really spread this out into all the states and all the counties.
I would agree with that, Roger.
May I?
Yes.
Under what conditions would Terry Trussell have to go through in order to apply this to his case?
The big issue with Terry is he has signed an agreement with a bar attorney.
Can I cut in there, Roger?
Yes.
He's already been acquitted by the common law grand jury.
Yes, people may be shocked by that, but he already was tried and acquitted of any of the criminal charges that were against him, and that was filed into the court and ignored. But once Terry signed on with an attorney, then he is in the statutory domain voluntarily. He has removed himself from the common law jurisdiction. And at that point in time, we no longer, as a grand jury or grand jury administrators, we cannot help him. If he were to sever the agreement with the attorney and do a document demand to amend with no delay asking for help, then we could step back in and help him.
If I may?
Yes.
The Florida Constitution, Article 1, Section 21 also says, the court shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. They're selling justice every time you have to get an attorney. They're selling justice every time you have to pay a fee to get before the court. That's all justice for sale, and it's unconstitutional. It's also a violation of the Magna Carta. I yield.
Great point. Thank you.
May I?
Yes.
It's also human trafficking. When the common law court results were filed in Terry Trussell's case, and the de facto ignored it, then it sounds like Terry was pretty much induced by threat, duress, and coercion and every other thing to get an attorney. Because apparently the de facto court was ignoring the facts. Am I correct?
He was threatened openly by the judge in the court. It's on the record.
Yeah. Okay. And Roger, I'm sorry, I don't. In 25 words or less, can you describe what they tried to set your brother up?
Yes. So the best idea is to read the affidavit, Santa Claus. The written affidavit will really lay out to you what happened.
I wonder what they were hoping.
I was told that after the case got dismissed, 2 days later I got a call from another patriot in Charlotte County. And he said, Roger, I want you to know that your brother only experienced the front end of the process. I said, what are you talking about? He said, what they will do is they'll get a jury that is malleable. They will prevent the jury from hearing any exculpatory evidence. They will convict him, throw him in jail, and then apply a policy called civil asset forfeiture against his house. Well, sure enough, my brother had been a successful commercial fisherman up north before he moved to Florida and retired. And when he sold his 200-foot fishing boats, he used the cash to buy his house, so there's no debt on his house. So that ultimately was, circumstantially, it appears to be the target. Civil asset forfeiture is costing Americans billions of dollars a year and is totally unlawful and unconstitutional.
May I?
Yes.
Has this been carried to fruition anywhere? Carried through, like out west, the Bundys or anything?
When you say that, are you talking about a grand jury effort?
Yeah, like what we're doing.
No, there is a very interesting aspect to the Bundy's case that is going on today. Let me just take a minute or two. When they tried them in Nevada for the Bunkerville face-off with the BLM agents, they divided the accused into the primary and the secondary defendants, and they tried the secondary defendants first. As a result of threats, duress, and coercion, some of the secondary defendants took plea deals. Some of them got tried and convicted, and they were awaiting sentence while the primary defendants, the Bundys themselves, went on trial. During the primary trial, a whistleblower inside BLM spilled the beans on all of the lies and corruption that had taken place, and therefore the primary defendants had to be, the case against them had to be dismissed. So that left the secondary defendants that were waiting for sentencing in a pretty weird position. How can they be sentenced for a crime that the primary defendants were released on? So the grand jury is watching this very carefully, the Nevada grand jury, and so far the sentencing has been postponed 3 times. And we believe it's because the de facto officials know that if they pronounce sentences on these secondary defendants, whether they were convicted or not, if they do, then the grand jury will come in and have a cause of action against them. So we're not sure how this is going to play out, but right now they just keep postponing the sentencing.
Okay, and the second question I have is, as you mentioned in the beginning of this, is that the Constitution basically, as we know it, doesn't exist until, back when, but that doesn't really make a whole lot of difference because we're going by the Magna Carta. Am I understanding this right?
Well, no. if you look at the documents towards the end of the documents in my brother's case, you will see that the common law grand jury is relying on both the Constitution and the Magna Carta. Both documents have principles in it, rules of law being very, very important in this case.
Okay, so technically the Constitution is still in effect, but it's does it still pertain to them as well as us?
Well, I think the most significant thing to take away from this is the combination of the seal of the grand jury showing up on the affidavit and the demand to amend with no delay, where the victim is asking for help for the grand jury. Those are the signals to the statutory de facto system that this case is going to be in the common law jurisdiction. So once they know that, that is a superior jurisdiction to anything they have. Okay? So therefore, I think that is the primary reason. In addition, the affidavit itself demonstrated the crimes. Anybody with education in criminal law can read that affidavit and see the evidence of all the crimes they committed against the victim. Okay. So I think in my opinion, it was those two things that really drove their decision not to go forward.
Okay. If I may?
Yes.
If the Constitution is not in effect, why do they still take the oath to it? Why do they still talk about it every day in government? Why do they talk about it on television when it supports their position? The Constitution is not dead. It's not eliminated. The Constitution is in effect. It's always been in effect, and without it, we have no system of government. So we do have a system of government, even though it's operating unconstitutionally. It's because of us. We, the people, are not doing our job to hold their feet to the fire under the Constitution. I yield.
And to add to that, what Hagen said, the essence of this effort is the signal of the restoration of the rule of law, and specifically the supreme law of the land, the Constitution.
The Constitution is also based on the Magna Carta.
Very much so.
May I?
Yes.
They're not swearing an oath to the United States of America.
That's okay.
Their oath is to the United States. They stop
Well, it
there.
depends which oath. In Florida, if you're a successful candidate for public office, you have to take 6 different oaths.
Wow.
Those oaths are required by Florida statutes, Florida Constitution, and the U.S. Constitution.
If I may?
Yes.
Take a look at the Supremacy Clause before mentioned tonight at Article 6, Clause 2. It says that the Constitution for the United States is the supreme law of the land, and judges in every state are bound thereby in spite of, notwithstanding, to the contrary notwithstanding, which means in spite of the state constitutions, the state statutes, and everything else. The prevailing law is the U.S. Constitution. It is not the state constitutions or the state statutes. The state statutes, codes, ordinances, and regulations do not apply to the people. The federal regulations do not apply to the people. The Constitution is the law of the people who are the sovereigns. It's the law to the government. It has both powers granted, delegated to them, and powers prohibited to them, both state and national. So understanding that, we need to pick it up and start using it. I'm using it in one of the court cases right now, explaining to the judge that ex post facto laws and laws impairing obligations of contracts are unconstitutional, and he does not have the authority to change that. I yield.
Folks, just a personal note. I keep a copy of the pocket Constitution with me at all times. And it's a well-worn copy. In fact, the folks at FreedomWorks, when I sat down with them, they saw it and they asked to take a picture of it. They had never seen one that was so well used. But at any rate, I keep it for two or three reasons. One reason is every once in a while I like reading it and I have a question about a particular aspect of it. But the second reason is that if for any reason a de facto agent of any type approaches me about any issue, I want to have it ready for reference and make it fully plain to the de facto agent that this is the supreme law of the land. This is supreme to any code or resolution or any statute that he or she may be trying to enforce.
Do you want to talk to the doctor to see if he can decide something else? No.
Okay, last call. Any questions or comments?
May I?
Yes.
Since this one has lasted about 2 hours, which is fine with me, the sooner you can send me the audio, the better off, because this is remarkable. This one. Yield.
Okay. I will try to. What happens is I have to wait an indeterminate time while the system that we use to record prepares the link that I then capture and send out.
Updates. Yeah.
Before I go to bed tonight, I'll check and see if I can't get it out tonight.
All right. I yield. Thank you.
You're welcome.
May I?
Yes.
Since it's agreed that the Constitution is the law of the land, how exactly does the Magna Carta fit into that? Since the founding of the country, at least from what I'm aware of, I never heard that mentioned. I've just heard the Constitution mentioned.
Okay, so remember, I mentioned at the beginning of the call that the British common law started in this country in the 1500s or thereabouts and throughout the 1600s, but it got converted into what's called the American common law. And that was based on the Magna Carta and another document called the Confirmatio Cartarum. The Magna Carta was written in 1215 AD, and then in 1297, the Confirmatio Cartarum confirmed that the Magna Carta was part of common law. Okay, so when you roll the camera forward to today, to 1776, when the founders in 1789 drafted the Constitution, they used the common law and the Magna Carta and all the other experience they had in life about how to write a document that would limit government to defined functions so that the people could remain free and independent. So when we talk about the Magna Carta, that is essential to common law. And when we talk about the Constitution, we refer to it as the supreme law of the land. So if you study that supreme law of the land, then you can make sure you're able to tell any de facto agent, elected or appointed, when they infringe on any rights, they deprive you of any rights, you're able to defend yourself. But if you don't know how that government was architected and what those de facto agents are allowed to do under the supreme law of the land, then you're going to be at their mercy. They're going to claim they can do whatever they want to you. Mostly they follow statutes. I've interviewed sheriffs, I've interviewed clerks of the court. They all say we run a statutory form of government. Well, that's not what the founders set up. The founders set up a Republican form of government, Article 4, Section 4. And when you approach that point of the discussion, you have a chance to educate them that they are way off course and they're in fact part of a unlawful, unconstitutional, and illegal corporation. which is a franchise of the D.C. Municipal Corporation or a franchise of the Territorial United States Corporation. Did that answer your question?
May I?
For now, yeah.
Okay. Yes, someone else?
Yeah, this is Paul from West Palm Beach again. Going back to the constitutions that you were just speaking of, there are 3 constitutions, and you just mentioned 2 of the constitutions. There's a constitution for the territorial United States, and then we have a constitution for the municipal United States. And our constitution is the Constitution for the United States of America. The territorial is the Constitution of the United States of America, and the municipal is the Constitution for the United States.
Thank you very much.
That's all. NFN Rights has got that all well spelled out in their postings and so forth.
Yeah, thank you very much for that education. Right now, we would prefer to be using the correct one, which is the Constitution for the United with a small U States of America. However, the pocket ones that are readily available are the Constitution of the United States, and we're finding that that is suitable enough for the time being. And when we get some extra money raised, we'll probably get the Constitution for the United States of America printed up and use that one. That is available. A certified copy of that is available from a library in Texas, from Liberty, Texas. You can get a copy of that Constitution for the United States of America.
If I may? If I may?
Yes.
The point that the gentleman just made is correct on the cover of the Constitution that exists today. If you notice inside the body of that small booklet, it doesn't use the uppercase letters, and the preamble does lay out the Constitution for the United States of America. However, in that document, and I do have a copy from Liberty Library, from the Sam Houston Library in Liberty, Texas. I've got a certified copy of the original. And it does say the Constitution for the United States of America. It doesn't have a cover. But the wording in the Constitution is predominantly the same. There might be a point or two here and there that is somewhat different, but for the most part it's the same. But the whole point about it is Article 4, Section 4, and I have checked that. It says the United States shall guarantee to every state in the Union a republican form of government and shall protect each of them against invasion. Well, that's not what they're doing, and the problem all comes down to us. Our not taking that Constitution and using it. Those other ones, we need not pay any attention to the corporations or the corporate nature of what they're doing. We simply need to stick to the common law, the law of the land, which is our law and not theirs. The other things that you're talking about is what they have done. The people didn't do that. So I yield.
Well, I would like to add to some context to what you said. It is my comprehension that the Constitution for the United States of America, small u, has the original 13th Amendment in it, the titles of nobility. Am I wrong?
No, you're right. It has the original 13th Amendment, but it's also enumerated in Article 1, Section 9 for the states and Article 1, Section 10 for the national. It's put in there twice, and Madison said that. He said that the amendment was unnecessary because those points were already addressed in the body of the Constitution. However, they did do the 13th Amendment. It is in the original Constitution, and it's enumerated twice. Thank you.
Thank you. Okay, anything else, folks? Last call, questions, comments?
No,
Hearing none, I'd like to hear a motion for adjournment.
Yeah, I put a motion for adjournment. I'm worn out.
Okay, a second?
I'll second that.
Second.
All those in favor?
Aye.
Aye.
Good night.
Thank you very much, ladies and gentlemen, for all of your support. Look forward to talking with you next week. Have a great night.
Good show.
All right, thank you very much. Good night.
Travel safe, everybody. Good night.
Good night.
Goodbye. Say good night, Dick.
Say good night, Dick.
Hey Charlotte County, this is Charlotte County COPWATCH, and I just wanted you to know that I am using this stuff under fair use. And also remember to like and subscribe this channel. Also too, keep in mind I do not make any money on YouTube. This is 5 hours work a day, you know, fighting for freedom. And you can donate with PayPal and Patreon. I just want you to think about this. If everybody gives to PayPal and Patreon, Patreon is every month. Actually, PayPal you can do every month. I have 12,000 subscribers. If everybody gives, I can quit my regular job and go full-time investigations on Charlotte County and possibly even more and beyond. So just keep that in mind. If everybody helps out, I can go full-time doing this. Thanks.